A very warm welcome to everyone present here today. My name is Tahhira Somal, and I'm a board member of the Jindal Society of International Law. Today marks the final lecture in our series titled Future of Internationalism and International Law. I'm proud to say that our lecture series has been so well received, recognized by bar and bench, and worldwide, giving our society the impetus to return with a renewed series next fall. Before commencing, I would like to thank everyone who could join us today in these trying times, and I would like to take a moment to pay tribute to Dr. Negan Pao Kipgin, whose sudden demise left us all in dismay. I owe much of my knowledge on the high seas to you, sir, and you shall be terribly missed. Moving on to our lecture today, the theme of today's lecture is International Maritime Law, and the topic of discussion is the aftermath of the Suez Canal bottleneck. Concluding our lecture series in the spirit of keeping the best for the last, especially in my list, we have none other than Mr. Amitava Majumdar, fondly known as Raja Sir. Raja Sir is the managing partner of Bose and Mitra and Co., the leading shipping firm law in India, dealing exclusively with admiralty and shipping law issues. He is an authority on maritime law in India, regularly advises the government on various issues, and is a part of the Prime Minister of India's Shipping Innovation Committee, apart from the Indian Council of Arbitration and the Singapore Chamber of Maritime Arbitration. Raja Sir has appeared before courts all across India, as well as appeared in English and Singaporean courts. His expertise is also in the field of international trade. Therefore, as Raja Sir in his daily life deals with matters on conflict of laws or private international law, augmented in shipping law, as in the maritime world, there is no easy reconciliation of the words jurisdiction, conventions, and national laws, and so on. On this note, we are in good hands today as we try and understand the issues in the Ever Given lodging incident by the authority who was involved in complicated issues like the MSC Chitra, MV Wisdom, maritime casualties, etc. I now request Raja Sir to please take the floor.
Good afternoon. Thank you very much for having me. It's a great pleasure to be able to speak to all of you and part some of my little knowledge on the aspects of shipping. Today I'm going to talk about shipping law and as well as the Ever Given incident. But before I go into the Ever Given incident, I think it's important for me to just give you a brief introduction to shipping so that gives you far more idea of how the further lecture goes through with the Ever Given. Now, I always do this with all my associates who join me, my juniors who join me, is I tell them that, look, shipping law is nothing more than what is the law, the domestic law of our land on a day-to-day basis. It's just that it plays in the high seas, it plays on a ship, it takes place in the sea, and the laws are slightly tweaked and internationalized to cope with the issues at hand. Just by way of a little example so that you have some perspective of, because I'm sure you've been studying the domestic laws of India, and just to put in some perspective to the whole issue. For example, you buy and sell houses. In shipping, we buy and sell ships, and that's also a similar conveyance which takes place. In domestic world, we take a loan from a bank, we put a mortgage on your house. Similarly, in shipping, you take a loan for your ship, and there's a registry, mortgage registry, where you have to also register the mortgage. In domestic world, if you are to lease a flat, you have what we call a wet lease and a dry lease, so which is more akin to a long-term lease or lease and a serviced apartment. In shipping terminology, if you are taking a long-term bare lease, that is called a bareboat charter, as opposed to a service apartment, which we would call a time charter. We also have contracts where you have a truck going from Mumbai to Chennai, and you can do whatever you want with the truck. And that, in shipping parlance, we call it a void charter party. Similarly, You may have a truck where you are sharing different cargoes with different other people and taking it from Bombay to Chennai or Delhi. And that would be covered under what we call bills of lading. In domestic world, you have cars crashing, uh, accidents happening. You have a car going and banging into a factory. In shipping parlance, we call it collision in sea. You have two ships which can collide. You have a ship which can hit a port, jetty, or also get grounded or stranded, as was the case in the Ever Given. You'd be surprised to know that even in the shipping world, we also have criminal law. The same criminal laws which are applicable on land are extended by our domestic law to apply to the EEZ and to all Indian flag vessels. So all ships which are registered with the Indian flag are susceptible to the Indian Penal Code because the Indian ship is considered to be a part of India, wherever it may be. And the line can go on. I can be talking about there are various aspects, both in contract and in general parlance on shipping, which have in some way correlative relation to what you have studied on a day-to-day basis over your many years at university, learning contract, tort, property, criminal. They have all have the same effect. But this is very important because you need to understand that with shipping, you're not learning anything greater than what you've learned, but you're applying it in a different method. The laws are tweaked because, of course, in shipping, you're dealing with a ship which is traveling and traversing the world over many, many different jurisdictions. And therefore, we have specific laws which have been put in place, both under public international law and under private international law, to deal with these situations. There is the United Nations body called the IMO, which is the International Maritime Organization, which has its head office in London, where various conventions are entered into, and these conventions are then ratified by various countries, and then they come into force. These are examples of these are maybe wreck removal convention, bunker convention, uh, uh, limitation of liability, etc. So these are the aspects. And also, for example, labor law, which you have also studied, employment law, that also has the same kind of relationship in the shipping world, but that is also dealt with by the ILO, and they implement certain regulations which are to be applied to shipping companies around the world, so that there is a sort of a standard to be used wherever the ships are going. If something were to happen, if a crew is a foreign crew on an Indian ship or an Indian crew on a foreign ship and they need some kind of compensation, there's a standardization of those compensations. Now, bearing this in mind, I will now move on, because if I wanted to talk about the different aspects of shipping, I could be here for a month or two on a daily basis and it would still not finish. But moving on, the Ever Given incident that took place was a extremely important incident as a case study to touch upon all the different aspects of shipping law, both the um, contractual part and the public international part of shipping law, and is going to have a major ramification from around the world. Now, to understand the incident, and before I go into the incident, I think a little background of the contractual part of it is important, because that is where most of the litigation is going to happen eventually. Today, the dramatization of the case is basically that, oh, it's in Suez. A lot of salvors came and had to get the ship out. Now the Egyptian authorities have arrested it. They want 600 or 900 million dollars. Unless they get that money, they will go. That's a very small aspect of this whole case, because once the ship puts up security or settles with the Egyptian authority, it will go. But the auxiliary litigations and legal implications that are linked with this incident will have far more grave effects all around the world. Now, this ship is a Japanese-owned ship which had been chartered to a Taiwanese company. I am not aware whether it was bareboat chartered or whether it was time chartered, but it was chartered on a long-term basis to a Taiwanese company. This is one of the largest container vessels which are there, and it is actually 100 meters longer than the width of the Suez Canal, which is why this caused the problem. Now, in turn, in a container vessel, there are different types of vessels. So you have tankers, which take oil. You have bulkers, which carry dry cargo. And you have containerized vessels, such as the Ever Given, which are container ships. Usually, in a bunker or a tanker container ship, the owner of the cargo is one, maybe two, but usually one. In a container ship, it's very different, because in a container ship, you may have 1,000 containers on it, and each container may be owned by different people. What complicates matter further is that the Taiwanese charterer would then in turn enter into further charters. It could be on a basis of time or on, usually in container ships, slots. So they divide the container ships and the number of TEUs, which is the containers that it can carry, and it then subcharters slots. So it could say, all right, Shipping Corporation of India, who's also a container operator, I will give you 100 slots. So that's another contract that comes into place. It could say, Maersk, I'm going to give you 100 slot. So another contract comes into place. But the cargo that Maersk and Shipping Corporation are going to carry is not their cargo. They in turn contract either directly with various shippers, or they contract with other carriers called the NVOCC, which are non-vessel operating common carriers. These are companies which don't own any ships. These are companies who just operate out of, take slots or a few places in a ship and issue their own bill of lading to a shipper. And even within this NVOCC, you will find that one NVOCC may give it to another NVOCC, who will give it to another NVOCC. And we have seen cases where there are many bills of lading roaming around. Now, tentatively, each bill of lading which is roaming around is a contract. Every bill of lading is a contract of carriage, as between the carrier who's identified in that bill of lading and the parties who are the shipper or the consignee. Therefore, in this ship, the Ever Given, all these various parties who are involved will in some way or the other want to raise a claim. It could be for claim for delay in delivery. It could be a claim for damage to the cargo. Maybe there's refrigerated cargo on board the ship, which is the food has gone bad. We don't know what it will be, but there will be different claims which will come through. Now, all the claims will not per se come up the line to the ship owner, because it is with their respective contractual party that the claims will come. And then that respective party will have an indemnity claim against their contractual party, eventually rolling it up all the way up to the ship owner. So therefore, in contract, you will have lots of claims which will eventually come up as a consequence of this delay that has taken place with the Evergreen reaching its destination. Because such a big ship would probably go to one port. From there would be feeder services, smaller container vessels, which will take this cargo to other ports. So there's a whole nexus of ships which is supposed to go to different ports. And all of that stands delayed right now because of what the incident has taken place. Now, when the contractual claims will come up, and as they come up, issues will arise as to title to sue. And there will be two types of claim. One is a contractual claim, and one will be a tortious claim. But for a tortious claim to come up, what will be needed is for the person who's suing to show that at the time when the incident took place, he had property in the goods, he had title to those goods. Because if he didn't have title, obviously he cannot sue. Only a person who had title at the time that the damage took place will have the right to sue. So all these aspects, there's going to be thousands of these small claims which will come up. Another claim which we are going through right now is the ports claim. The Suez Authority is claiming that there was negligence on the part of the ship, and therefore the ship is liable for all the delay, including business loss, consequential delay, economic loss, etc., etc. Now, I am not an Egyptian lawyer to be able to advise you how the Egyptian courts are going to deal with it. I have what I propose to do is, if the similar incident were to take place in India, how would the incident take place? In a lot of countries, pilotage gives a strict and absolute liability. Therefore, if a pilot mistake takes place, the ports will say, maybe it's my pilot, but he was your employee during the tenure, and therefore any damage that he has done is deemed to be a damage done by the ship, and the owner is responsible, and there's nothing that you can claim. Now, under Indian law, the damage to port property or delay in ports is dealt with what is called the Indian Ports Act. Right? The Indian Ports Act, it has come up for review now, but as on date, we still go by the Indian Ports Act. It's a 1905 act, if I'm not wrong. But our act provides that the ship owner is not liable, but is answerable for any damage. Now, there's a huge difference between the word answerable and liable. We've been involved with various cases in India where ships have damaged jetties, ships have damaged port property, and the ports have said, well, you just have to pay. And we have in turn sued the port because, of course, the pilot is an employee of the port. And we as ship owners have paid money for pilotage, expecting a certain amount of knowledge-based experience of the pilot. And if the damage took place because it was a pilot error, because normally when a pilot gets on board, especially like in Suez, I would imagine, or in India, when a ship comes to anchorage and it has to be coming into a berth and there's compulsory pilotage as there is in the Suez, then the pilot comes in, and after taking a briefing from the master, the ship is then under the command of the pilot going into the berth or through the canal. Therefore, it would be certainly to the judgment of the pilot to a certain extent, which you would attribute any damage which may happen. So if it was to take place in India, for example, you would say that, look, you were in charge. I'll give a small example which we had, where a container ship was damaged, a jetty, and the pilot knew that he needed to have 3 tugs, but only asked for assistance of 1 tug. And as a consequence, the ship went and damaged the jetty, but the ship also got damaged. So the ship owner sued the port, saying that because of your pilot, my damage to the ship has taken place. The port then came out with an application saying that no, this is once the pilot goes on board, he's your employee, and under the Indian Ports Act, you're answerable for it, and therefore we don't have to be liable for anything. The courts, the Calcutta High Court, and then the Supreme Court, who's affirmed this judgment, and the Kerala High Court, have all held that answerable does not mean liable. Answerable does not mean liable, and therefore you can't pin liability on the ship owner for something which may be the negligence on part of the pilot who's the employee of the port. So there will be issues which have to be dealt with. I understand from whatever has been available publicly is that this is a bad weather season in the Suez. It's actually the beginning of a season called the Khamsin, which is a roughly 50-day period in which sporadic powerful dust storms blow in from the Sahara. So as you will remember, the incident which took place here was that when the ship was going, there was a sudden sandstorm. And as a result, we understand, we're given to understand that the wind hit the containers. As you can imagine, a container ship has this wall of containers which is sitting there, and hit the container and turned it around. And because the ship was, I think, 100 meters longer than the width of the canal, it got stuck. So the issue which will arise, and there will be evidence which has to be given, will be whether the pilot ought to have known that there could be sandstorm, whether the pilot ought to have found out whether the ship should go in, whether the owners ought to have known about it. All of this will be issues which have to be decided at the time of the port's claim. The next thing that will happen is, because there are all these claims, what did the owners do? The owners got salvage company in to try and get the ship out of the way that it was, so it could then become straight and sail out. And why did the owner do that? Did he do it only because of his ship? The answer will be no. The owner did it because of his ship and to protect and to look after all the cargo which was on board the ship. And therefore, he then declares what is called general average, because he says all this expense that I've incurred is for the benefit of all of us, whether it be me as the ship owner, whether it be you as the charterer, and whether it be for saving your bunkers, whether it be for saving all the cargo. Now, when general average is declared, then all the claims come in, and the salvors who've come in, and they may come in under contract, which is called the LOF, they have a lien over the ship and the containers. And each container owner, or the receiver or the owner of those cargo, not the container, but the cargo itself, will have to, along with the ship owner and the charterer for each party, will have to give a bond, guarantee, which they will have to give, so that later on, when the general adjuster adjusts, so I'll give an example. Let us take this ship is worth $10 million. Let us take the bunkers on the ship is worth $150,000. And let us take that the cargo is worth $100 million between different people. The total claim that has been spent in getting the ship out, the damages paid for port, etc., all come to, let us say, $50 million. Now, the general adjuster will sit there to calculate, depending, of course, there are rules which will be followed, but apropos, they come to a conclusion that, okay, because on the basis that, look, the owner saved his $10 million ship, the time charterer, what is the time charterer's interest is only the bunkers in the ship. He has saved $150,000, and $100 million is the cargo owner, basis various cargo owners. He will then will do a ratio and say, this is, if X amount is what has been spent, each party will have to pay apropos that, which either the party pays or the insurance company pays. Now, this results in another litigation, in that each party can challenge that as well. Just because the GA adjuster says you have to pay this doesn't mean that you pay. The general average is governed by what we call the York-Antwerp rules, and therefore a party can challenge the GA adjustment. But because the salvors give away the vessel or the cargo, they will keep security through these bonds. And that's another level of litigation which will take place. Now, another round of litigation which will be coming into play is each of these contractual parties. If you remember, I told you there's the owner who has a time charterer, who may have slot charters, who then give it to various NVOCCs, and there may be direct receivers as well. Now, each of them may have raised a claim against the contractual party, who's the bill of lading carrier, not always the owner, because like NVOCCs, the NVOCC is the carrier. Or in a slot chart, if I've given it to SCI, SCI may issue their house bill of lading as being the actual contract of carriage. So the party who can sue is only, they can sue SCI or they can sue Maersk. They can't go to the owner. But Maersk and SCI in turn, under their contract with the owner, will sue up the line. So it's a So rollover suing which will take place, and there'll be multiple litigations. Now, also, as I said, there could be a tortious claim, in which case anyone who owns the good, doesn't matter the bill of lading, if he owned the good at the time of the damage, can also sue the owner directly. To protect this whole situation, they will file what is called a limitation of liability action to limit liability. So that, and these are governed by the limitation of liability convention, and we have had the 56 convention, 52 convention, then the 76 convention, and then we've had a 96 protocol, and then the recent 2014 protocols enhancing these amounts. But the idea of forming these limitation of liability funds is that once the fund is created and once the owner pays the fund, then all actions vis-a-vis that incident arising against the owner or the charterer, if they become party there, will have to all be taken place in that one court. So you can't then go to 50 different courts and sue the owners. But again, when that happens, you have to be a limitation of liability fund country. If you're not, then it won't apply. Now, I understand that the owners of the Ever Given have filed a limitation of liability action in England. And they have also filed an action against their charterer because their charterer in turn had appointed a management company to manage the ship. So they are obviously going to bring that claim down the line back to the managers. It all depends on what kind of insurance people take, whether they're covered or not. But if this incident, if the same thing happened, and let us say today someone wants to bring an action in India, the question that will be posed is, can the fact that there's a limitation of liability fund action which has been started in England stop anyone from suing the owners in India? The answer to that will be that India doesn't believe that you can forum shop for limitation of liability. Secondly, this particular ship had a Panama flag. Under Indian law, if you are not a convention country, and Panama is not a convention country, then you cannot limit, the ship owner cannot limit liability. Thirdly, India would say, and as per the judgments in India, India would say that England doesn't have any nexus to this claim. Therefore, you cannot go to England and file a limitation of liability. And therefore, if someone chooses to come to India and file a case because the cargo was supposed to arrive under a bill of lading in India, then they may have a right to file action in India as well. And the limitation of liability action or any injunction passed may not have any effect in India. Again, this is where private international law and public international law, conflicts of law, all come into place. Because if today England does pass a judgment, for example, a reasoned judgment, now that would have to be is an enforceable judgment in India under Section 44 of the ACPC. The questions and arguments which will have to come out is that judgment against our Indian public policy, etc. So there'll be a plethora of issues which will then come up with this limitation of liability. Now, after this, so this is all the contractual. As you can see, it's not an easy case. And we have been dealt with container cases where you have plenty of people suing because because the other reason people sue is every container owner has got an insurance, right? Marine insurance on that particular container for the transit. If, let us say, they don't know whether this container will come or whether the container will be damaged, whatever, or when it arrives, it's in damaged condition, the container owner, when he files his claim with the insurance company, is under an obligation to act as if he is an uninsured. So while his insurance claim may take 3 years, under the Hague rules, which govern bills of lading, depending on which country or what the bill of lading says, may have a 1-year time bar. If it has a 1-year time bar, then in that event, if the cargo receiver, the cargo owner, hasn't initiated an action against the carrier under the bill of lading, then in that event, the insurance company may reject the claim by saying, you haven't protected me because you should have acted as a prudent uninsured. What would you have done as a prudent uninsured is that you should have started your claim and then subrogated it to me for payment. So all these thousands of container owners will have to make sure that they protect themselves. Now, if the bill of lading is governed under English law, or if the bill of lading is covered under the Hague-Visby rules in the country where the shipment was made, then the carrier, the cargo owner can, if the bill of lading so permits, ask for an extension of the limitation. And if this was an English case, they would ask, and usually the English lawyers will agree to give a 1-year extension. Now, apropos India, under Indian law, because we have the Limitation Act, the law says that unless there is a statutory limitation, you cannot by agreement extend or reduce limitation. So for example, the Hague-Visby rules, which apply, the COGSA, which applies to bills of lading in India, which is a pre-independence act, which is a 1925 COGSA, which had the Hague rules. Certain aspects of the Hague-Visby rules were brought in through schedule of the Multimodal Act into the COGSA. But even when that happened, there was a 1-year time bar. But Indian Act only applies statutorily for outgoing cargo. So for export cargo or for coastal cargo. It does not apply for import cargoes. For import cargoes, it is the law of the land or of the port of leaving. But let us say an import cargo comes in and you incorporate the Hague-Visby rules, which provides for a 1-year time bar with an allowable extension. If you ask an Indian ship owner or the ship owner with, and let's say the jurisdiction is India, can you please extend the time bar? They cannot extend the time bar because that extension of time bar goes against our Limitation Act. So while export cargoes have a limitation of 1 year, import cargoes have a limitation of 3 years. So the limitations are different. So again, that whole thing will play on all of these contractual nexuses which will be there. These are the bill of lading claims. There'll be claims under the charter parties as well. So all of these claims will be coming out in this ever given. Now, the other aspect, which is a huge aspect, is the salvage itself. There has to be a reward which will be paid for salvaging the ship. There'll be a claim which has to come from the owners, the charterers, and the cargo owners. And that will be another set of litigation which will go on between the insurance companies or the receivers and the salvors who will try to work that out. Now, salvage is not subject to limitation of liability, at least under Indian law. So whatever the salvage claim will have to be paid irrespective. And the salvors have the first right under normal maritime liens. They have the first right over the vessel. In India, they have the third right after the crew, second right after crew claims, because we are a crew-oriented country under our Admiralty Act. But normally under the Maritime Liens Convention, the salvors have the first right. The concept being that if I didn't salve the ship, you would not have anything. So where's the question? So we must be paid first. Now, one other angle which comes out of the ever given is the crew. Because one of the things that people will start saying is that it was the master's fault. Did the master give proper? And then there will be, depending on the law, domestic law of that country, there could be criminal sanctions put on or civil sanctions put on. You will remember the case of the Hebe Spirit, which took place in Korea some years ago, where there was a huge oil spill on the Korean beach. And the master was ordered for 2 years imprisonment, because that was the law for any pollution. So there will be an angle of the crew which will come in. The local authorities in Egypt may hold back the crews just to pressurize the owners to settle. Many years ago, now India has moved very much forward. When I started practice, this was very much taken into account, and there would be a oil spill or a damage to something, and then the ship would be held back and the crew would be held back, their passports held back, and they would not be allowed to leave, because they would think by doing that they would then pressurize the owners to come and settle. IMO came up with what is called how the treatment of seafarers post an incident. I was involved in a very interesting case in the Andaman Islands, where two ships, one about one ship was, let's say, before I went and filed the case, 2 years behind, came and crashed into some coral reefs, and it had an Indonesian crew on board, and they were kept in Port Blair. The next year, I had another claim from a Vietnamese ship, which also similar thing happened, and the Vietnamese crew were not allowed to leave. And their contention was they were just saying, we're doing investigation, and the owners didn't come forward. So we filed a writ in the Port Blair, in the High Court of Calcutta, Port Blair branch. And it was a very interesting writ, because it dealt with this IMO circular for treatment of seafarers after an incident. And the court was horrified that the crew had been kept there for so many, well, one for 2 years, and directed that they be immediately, forthwith, be sent back. In fact, the Indonesian crew had stayed there for so long, some of them even had got married, and they came up saying, we don't want to go. But, so there will be the human aspect of it, which will come in. We don't know what will happen. The crew, whether they're going to be allowed to come back to India, are they going to hold back the crew? Are they going to hold the master? So all of these aspects will have to be dealt with. So as you can see, the 6-day incident of Ever Given will cause multiple faceted litigations, which are all dealing with different types of shipping issues, starting from charter party disputes, bills of lading disputes, marine insurance disputes, cargo claims, salvage disputes, general average disputes, crew claim, port disputes. All of this will have to be dealt with. So one small incident in a shipping incident can really have a cascading effect. Funnily, they can also settle as quickly sometimes, and sometimes they can go on for many years. So I hope that was helpful. And if there's any questions anyone has, I'm happy to answer.
Thank you so much, Raja sir. That was this very complicated issue was explained very succinctly from the Indian point of view. Before I open the floor to questions, I just wanted to say that while I was preparing for this talk, I got a sense of how multifaceted this issue is, inter se contractual claims between the ship's stakeholders, then tortious third party claims in the form of the Egyptian authorities as well. And now, also, as you rightly pointed out, the newest dimension of the Evergreen's claims on suing the Egyptian authorities for detaining the seafarers. And also, this shows how multidimensional maritime law is generally. So there are a lot of other questions that come up apart from compensation. And I think the human element is an important dimension. Once before, also in the case, as you pointed out, the case of MV Aman, a Syrian seafarer was stuck on a ship for, I think, about 4 years as a result of detention. So this was because the seafarer was designated as the vessel's legal guardian, because of which he could not leave the ship until and unless it was sold. So in one way, even though the Ever Given is free, it is not really free yet in the legal sense, and also in that physical realm as well, considering the human element. So a lot of other questions also, I think, come up, such as the flexibility of the York Antwerp rules, which govern the general average claims domain, and also the question as to when does the common maritime adventure or the common peril end, like within the meaning of the rules. So since if it is seen in one way, it is still continuing in that sense. So there are a lot of questions that can be asked. And on that note, I thank Raja sir for his really interesting insights. And now I open the floor to questions. But first, I would like to ask the members of the Maritime project to please ask their questions. First, we have Nishank. If Nishank, you could please introduce yourself and ask your question.
Yeah, hello, good evening. Good evening, sir. I actually can't turn on my video for some technical reasons, but
Good
it was
evening.
great hearing you on this topic. I noted down the fact that you're talking about LOF, and my question was in that particular regard. So, sir, there are two basically domestic legal instruments. The one is the nationalization of the Suez Canal of 1956, and then there is this law number 30 of 1975 on the organization of the Suez Canal. Whereas the 1989 ISC Article 13 criteria, that opens the floor for the future implications or arbitrary proceedings that can take place with respect to the evergreen. So, could you share your take on that?
I will not be able to share my take on that much because I have not dealt with the Egyptian laws. So I'm sorry, I'm not going to be able to give you that answer.
Okay, Professor. So, can I ask a follow-up question?
Yeah,
Because
sure.
yeah, okay. So, with respect to the Indian proceedings, like you talked and related it to the international law, if a conflict of such dimension would arise with respect to India, would then the principle of how would then the principle of general average come into picture? Because for the with
You
respect to the yeah, yes, sir.
So usually general average is something which is set out in the charter party itself. And the charter party will set out that which is, so normally it will say GA, which is general average, English law to apply, or GA Indian law to apply. And therefore, once GA is declared, a GA adjuster is appointed, and usually a GA adjuster of that country or with that knowledge is appointed. And then once he issues his GA adjustment, the court of the law which is set out in the contract to deal with the GA will then deal with the aspects of the same.
All right. Okay, Professor. Right, sir. Thank you.
Thank you.
Okay, we have another question. It's typed out, so I'll just read it out. It says, it's by Ishika Mittal. She says, "Hello, sir, I have a question for you. What if negligence is found on the pilot's part for guidance, the salvage operation leading to further damages? Can claims be bifurcated as such, levying responsibility on different parties, and how would compensation work in that case?"
Well, much would depend on what the Egyptian law on that is. Uh, if this incident were to take place in India, the negligence, the question will be whether the pilot was negligent or not. There's either the pilot is negligent or he is not negligent, or is the owner negligent. So depending on the law, which is specific, as I said, in our Indian law, in the Indian Ports Act, the provision says that the owner is answerable in the first place. He has to bring out the case as to whether or not he is responsible, or whether or not the pilot who was bringing him in, or the berthing master was berthing him, was responsible. And he has to prove that. Does that answer your question? But you can't, I don't think you can bifurcate the claim. Either one or the other is responsible.
Next, we have Ankit. I see your hand raised. If you could please turn on your mic and ask your question, please.
Yeah. My question is with regards to ship owners and general participation of the IMO. And my question really talks or seeks to get an answer with regards to the IMO and its overarching functions with regards to ship owners and shipping companies. I mean, this is a incident which has got headlines of the full globe, but this is something which has happened again, and especially with regards to shipping in a rather difficult time. The first incident really being Beirut and the blast which took place at the port, and also now Suez Canal. So my question to you, sir, is that is the IMO in some sense failing in terms of creating some sort of a regulatory framework from different aspects and for different players in the industry? And this becomes even more important because Suez Canal is just one canal. There are other canals also which are extremely important, and at least in South Asian region, you have Malacca, which is a global hotspot and is dotted with incidents of piracy. And then if you go into the South China Sea, that's a whole different story altogether again. So my question to you is, how much of effectiveness of the IMO is there, or is there a lack of that?
I think the IMO is very effective. You see, you must understand the IMO doesn't deal with private law. The IMO deals with public international law. The IMO deals with the nations deciding how they want to deal with vessels who enter their waters and how do they safeguard themselves. To that extent, they have created the various conventions, and it is up to each country who wants to implement that convention that that it matters. So that if a country who doesn't implement, let's say IMO has brought out regulations, and the country chooses not to be a signatory, the IMO can't really be blamed because it's not an organization which can impose the convention on everyone. It can only say we've all these nations have agreed to draft this convention. X number of people have signed this convention. It's now come into force. And now, whichever country wants to implement it domestically can ratify it and inform us and then bring it in. And then they have to bring in their own domestic laws. For example, in India, we are signatories to the wreck removal convention. We are signatories to the limitation of liability convention. We are signatories to plethora of other conventions. But we are not signatories as yet to the bunker convention, for example, which we want to. But at the same time, in our domestic regime, while we have brought in the limitation of liability regime, we have yet to bring in the wreck removal convention. But till it is brought in domestically, it has no implication. I mean, of course, our case laws say that we can import it, but there's no domestic legislation dealing with it. So what really needs to be seen is whether the countries who are implementing it is implementing in a true spirit of what the IMO has done. They should not tweak it. A lot of people tweak the conventions. So it's not the IMO's failing at all. The IMO is working overtime to ensure that all steps, all conventions are brought in, which will protect every country. I mean, the latest one being the limitation of liability being increased by the Japan convention, but only I think 11, I think 15 countries who are 1996 convention, it's an automatic entry. The rest have to sign it. If they don't sign those conventions or don't bring in those protocols, then it doesn't apply.
Thank you so much for your question, Ankit. Next, I see Niharika. Your hand is raised. Please turn on your mic and ask your question.
Good evening, sir. Thank you for that very enlightening talk. So actually, I was wondering, so when you, in the beginning of your lecture, you started with telling us about how pilots of a ship guide the ship into the port, and oftentimes the liability is, they're liable or answerable either way, depending on the port or the ship. So by the sound of it, and please forgive my very limited knowledge or no knowledge actually, which is that it sounded like if the pilot is an employee of a particular port, that to me feels like every port will have their own pilots. And so let's say an outgoing ship going outside of India and docking into, let's say, an English port, at the time of docking in England, would they need a pilot of the English port or the Indian port's pilot?
No. The pilots are for, it depends if, so pilots belong to the ports where ships are coming in. Some ports have compulsory pilotage, some ports don't have compulsory pilotage. So if the port requires that you must use a pilot to come into my port, then that port's pilot will go of that country.
Right.
They're based in the ports. They don't travel with you. So, for example, the Suez Canal guy will get on one side and then get off the other side before it leaves the Suez Canal.
Right, sir. So then in that sense, it makes absolutely no sense to hold individual shipping companies or contractors liable for the mistakes of a pilot
So it depends from country to country. Some countries, it's an absolute liability, irrespective. Some countries, like for example, we have managed to uh, bring out the fact that our statute doesn't say liable but answerable. But the question of answerability is also, for example, if the pilot had asked for 3 tugs and the owner said, no, let's have 1, then the courts will say, well, the pilot said you chose not to, then that's not the pilot's fault at all. This damage was caused as a result of you not having brought in all the tugs that were required. So it depends, very factual, and also depends on the legislation of each country as to how they have made pilotage, the liability of pilotage.
Right, sir. So may I ask one another question?
Of course.
Which is also sort of on the human aspect of it and on labor laws. So I was wondering that all of the crew of the ships must definitely be governed by some labor laws, but oftentimes we could have because ships are so um, transient in the sense that they don't have a fixed place of business. So seafarers or the ship or the crew on that ship will be governed by the law of the outgoing country or the incoming country or the place where the ship is from.
Okay,
I'm
so
sorry if it's too basic,
the
sir.
contract of employment will be as per the flag or the company who employs, because that's the employment contract.
Right, sir.
But each country can decide on what the liability, usually it will be the liability mainly of the master, because he's the one who's at the helm.
Right.
Right? So that if there's a negligence which is caused, then of course the law of that land will decide how the crew are going to be dealt with.
Right, sir. Right.
So, yeah. So, for example, let's say, let me give you an example. Let's say in India, the murder takes place on a foreign flag vessel while it's in Indian waters. Then the IPC applies because of our notification, which extends the CPCRPC and IPC up to the economic zone under the international continental shelf act. But if the murder was to take place in high seas beyond 200 nautical miles, while going, let's say, from India to Mauritius, and it's on a Nigerian flag vessel, then the Nigerian law would apply.
Right. Right. So a basic public public international law
Correct.
principle.
So I'll give you. We have had an example where there was a incident which took place on an Indian vessel, but in high seas, and the ship went to a foreign port, and the foreign country required that the owner bring the Indian embassy or the Indian police to take that guy. So we had to arrange, or the owner had to arrange for Indian police to fly down to that country, go on the ship, arrest that guy, fly him back into India, because the incident took place on Indian soil because the ship is Indian, so long as it's not within the country's water.
Right, sir. Yes.
Yeah.
No, yes. Thank you so much, sir. Thank you.
Just to add to Niharika's first question, I think in the case of Egypt, in the Suez Canal Authority Act, it is a very detailed statute. It specifically says with regard to pilots that it actually disclaims the liability of pilots. So even if there's negligence on the part of pilots, so that is completely disclaimed. But thank you so much, Niharika, for your really good questions. Next, I would like to ask Sai Anukaran. Your hand was raised.
Evening, sir. Thank you for your very insightful discussion on such an intricate issue. We really learned a lot from you today. My question is slightly concerning a topic that you did not deal, but apropos the other ships who were also stuck in the Suez Canal because of the evergreen blockage. Will the principle of force majeure apply for any delays caused for their deliveries?
So force majeure is a contractual term. There's nothing really common as a force majeure. Force majeure depends on your contract, what you've defined as a force majeure, right? So if the other ships had provisions in their contract with their counterparties holding that if I am held up because of a ship being stuck in the Suez Canal, which will be a force majeure event, then it would apply. So it really depends contract to contract, what you have defined in your contract to be a force majeure.
Thank you, sir.
Next, we have some typed questions. So, Sanchali says, "Good evening, sir. Thank you so much for your lecture." She wants to ask as to what extent can the ships lined up in the blockage claim for ever given for damage of their cargo?
Again, that depends. The issue is going to be an indemnity claim. The issue is going to be, it could be an indemnity claim, it could be loss of hire of their own claim. It would depend. It's a tortious claim. It's no contract. So they would have to prove whether there was a duty. And if there was a duty, for example, if they're able to show that it was the wind which actually caused it, which is beyond their control, then there would be no damages claimable at all. There would they would also they may owe a duty to the next ship because they knew if they're held negligent, but to be liable for 20 ships down the line may be too remote and not foreseeable. So all those tortious elements, I know the law of tort has not developed very much in our Indian jurisprudence, but all the aspects of the tortious elements will have to be dealt with and decided on the facts of the case to see whether the evergreen would be liable for any claim or damage of the other. Would the evergreen know what is the nature of claim that, damages that is being suffered by the other ship, etc. So it depends factually.
Next, I think we have two more questions. So, Nikita is asking that what's your take on whether the grounding of the ship was due to negligence or natural cause, as you mentioned the dust storm? And if it is negligence, what will be the implications on the owner of the ship?
Well, if the owner is, well, it all depends again, if it is a tortious claim or it's a contractual claim, bill of lading claim. I can't tell you whether it was due to negligence or natural causes. If it is due to natural causes, then the owner may be able to rely on the Hague-Visby defense of peril of seas, but then they would have to show whether it was an occurrence which suddenly happened or it's something that they should know of, which is why I said that I understand that ship went in at a time when these kind of sandstorms are quite regular. Has this kind of incident happened before? What is the reason for it? There are rumors roaming around where people have said there was a blackout. If there was a blackout, was that the owner's fault, manager's fault? Then, of course, the ship owner may be liable, in which case they will have to rely on the limitation of liability. Eventually, the claim may be limited by the amount of limitation of liability which we form. But it all depends. The case is right now at such a nascent stage. Facts have not come out. Unless all the facts come out, it will be premature to decide how it will happen. But obviously, if the ship owner is liable, then he will be liable to pay. If he's able to get out by the defenses under the Hague rules, then he will have to prove, because if it was Indian law, the ship owner would have to prove first that he falls within those defenses.
Okay, so next is a query on the York Antwerp rule. So the question is that how will the general average be exactly calculated? Will there only be an application of the York Antwerp rules?
Again, it depends on the charter party between the owner and the charterer. What is the applicable law? If the applicable law, let's say, usually is English law, then the York Antwerp rules apply. When the actual division takes place, who gets what. And then the adjuster will have to apply that. But any party can challenge it. Just because he does the adjustments as per the rules doesn't mean it is sacrosanct.
Okay. Next, Nishank, I see your hand raised again. Do you have a question?
Yeah, I have another question. I heard sir talking about the seafarers thing while answering it. So I have a question in that regard. So, like both the Indian government and the seafarers organization are basically concerned about the possible legal implications that could arise. However, sir, what could be the clear danger? Because Sanjay Prashar, he's the member of the National Shipping Board. He wasn't really while in his statements he wasn't really clear about, as like you said, the facts need to be examined, and the entire conversation about the voice data recorder needs to be heard and all that. But sir, what could be the legal implications for the 25 people that were there?
I don't think all of it, the legal implication usually is only of the people who are on the bridge. So While there are 25 people on board, normally they work in shifts. There are 8-hour shifts. So you'll have the master, you'll have the chief officer, you'll have the second officer, you'll have the third officer taking shifts along with an AB. Normally, when I would imagine when they're going through the Suez, I think the master and an officer will be on board. So it is those people who would be the ones who would eventually be, if there's any prosecution which has to be done, if there is under the law in Suez, then it would be they who would be prosecuted, not the rest. The rest would probably, after investigation, they'd just be allowed to go. As I said, unless the Suez authorities are holding them back as a chip to try and see if settlement can be reached or not.
Yes, sir. All right. Thank you.
In fact, there is, as I said, there's an IMO regulation which deals with dealing with seafarers after a maritime casualty. And in that, it says you can hold them back for a reasonable time. But if you hold them back for longer, in fact, the authorities have to pay them to keep them.
Okay, I think since there are no further questions, we can conclude the session. I just want to express my gratitude on behalf of Dr. Veselin Popovsky and the Jindal Society of International Law and myself to Raja sir for being here with us today. Also, thank you to everyone present here through Zoom and the YouTube channel, even during these trying times. Thank you, everyone, and thank you so much,